4-1, State of Wisconsin versus Heather Honeycutt. Ms. Honeycutt pled guilty to count 1, burglary of a building or a dwelling, she pled guilty to theft, movable property greater than $100,000, a felony F or an F felony. Is the victim or one or more going to be making a statement?
Yes, yeah.
My wife and I are local business professionals and taxpayers of the county. We give back to our community by donating time and money to local organizations, including Lakeland Family Resource, Sacred Heart Church, the Spooner School District, Scott and Spooner Fire Department, snowmobile clubs, and the city and county law enforcement. My mother, Mary, is a widowed, retired special education teacher who taught in the Frederick School District. I have never met Heather Honeycutt, and she has never had my permission to be on my property. My only knowledge of her is that her and her boyfriend are friends with my former contractor. In March of 2024, I went into my pole barn and the door was unlocked, which I thought was strange. After going inside, I look over and a lot of my property has been moved around. And in the corner of my barn, I saw that my mother and my family's safe has been dug up and stolen. After my family passed away, I had major issues with the bank getting access to my safety deposit boxes. So I just decided to buy a safe, put all the estate items into it, and bury it where no one knew where it was. Inside of the safe was my 9mm handgun, my grandmother's multi-generational diamond ring, my great-grandfather's watch, and gold and silver coins, and multiple other family property that is irreplaceable. The only people who knew where that safe was located was my wife, my mother, and my father-in-law who helped bury it. The thieves were able to get into my pole barn without any forced entry. And the only person that had a key prior other than my family was my former contractor who was friends with Heather. The thieves or Heather somehow knew right where that safe was located in the back corner of my pole barn, buried underneath a foot of dirt where I had heavy machinery and deer stands on top of it. It was located where no one would ever know where it was, and it hadn't been touched in years. There's no possible way any one person could have lifted that safe by themselves, and I know Heather had help in stealing this safe. And I would gladly agree to no sentence if she would just tell me who the main people are responsible. My mother is a widowed elder woman, along with myself, my wife, and my 2 young children, age 5 and 2. Knowing that Heather and other thieves had came onto our property and stolen a firearm, along with my family's legacy, makes me extremely anxious, afraid, and we do not feel safe in our own home. I've had to spend significant amount of money to install additional security measures so our family can still continue to live at this residence, but in fear. Since the initial theft, we have been targeted again and another shed broken into with no other neighbors broken into, and the person on the footage has a very high resemblance to Heather's boyfriend. Law enforcement is very aware of the other parties involved, and these people have no respect for law-abiding citizens. The dollar amount of this theft is also extremely high, but the monetary amount doesn't really matter to me as much as my family heirlooms, as I would give anything to have my grandmother's multi-generational diamond ring back, because I was going to give it to my son to give to his future wife someday. The amount of this theft, as you stated, qualifies as a Class F felony. If she would just tell us who the main people are responsible for this theft is, I would gladly agree to time served. But with the amount of theft, no cooperation on naming the others involved, no recovery of the firearm, and never being able to get my family legacy items back, I think the plea is light in terms of sentencing if she is going to take full responsibility for this. I thank you for your time.
Thank you.
This is a joint agreement for 18 months initial confinement, 42 months extended supervision and costs. And she's the one who happened to leave behind evidence. A cigarette butt at the crime scene where she told law enforcement she'd never been, the presence of her phone in the same area where she said she'd never been to, suspicious messages between her and the only other man who's not in Mr. Fry's family who knew where the safe was buried. And then some of the stolen property started to be recovered to people that can be connected through her 7 degrees to Kevin Bacon style through phone logs, Dakota Barf to Justin Pfaff to Heather Honeycutt. Law enforcement obviously has strong suspicions about certain people connected to Honeycutt who have substantially more criminal history than her, as being the main people involved in planning and executing the heist, as well as the contractor who knew where it was buried. We've talked about that at length when we talked about previously at the plea hearing and why it's in the public interest for this a plea agreement to be. The reason there's only enough evidence to convict her versus them is likely because of their greater experience and skill at avoiding incriminating themselves. Basic things like not talking to the police, not keeping their cell phones on their persons when they're committing crimes, not leaving behind physical evidence. This is the primary reason for the joint agreement. This is clearly not one of the main people primarily responsible for planning, thinking up, and executing this heist. If it was, she would have posted bond long ago, as her bond that she's being held on cash for is a fraction of what this property was worth. Instead, the stolen merchandise has been, stolen property has been showing up in the hands of other people who are either more responsible or are friends of people more responsible. That being said, given the nature of the burglary, literally a safe heist of possibly the largest amount of valued property stolen in the history of our county, probation would unduly depreciate the seriousness of the offense.
While she has been in custody awaiting this day, there's been a limited amount of services that she could have received in the jail, but the ones that were available, she took full advantage of. And I think you can see that from the letters that were included in the sentencing memorandum. Thou shalt not steal. It goes back to the 10 Commandments. That is how ancient this offense is. And the legislature has seen fit to classify this offense as a misdemeanor. What makes this such a serious offense, what makes it a Class F felony, is the value of what was taken. Not necessarily that any aggravating factor in terms of how the theft was carried out or what was done with the property or to who. It simply comes down to dollars. So I ask you to keep that piece of it in perspective. No one was physically harmed. No one was threatened with harm. There was no violence alleged by anybody. No threat of violence alleged by anybody. Is that she is not a danger to the public. Heather's mother and her daughter, Candace, wrote to you, Judge, and I'm just as miffed as they are that Heather wanted to plead. This case to me is one that should have been tried. True character is how you act when the chips are down. The chips have never been this down for Heather. We've done our best to tell you her life story in the sentencing memorandum, and there have been some downs. There have been some downs, but the chips have never been this down, Judge. And so I want to draw your attention to page 14 of the sentencing memo, who, as far as I can tell, was a perfect stranger to Heather. And I want to quote things that Crystal had to say about Heather when she met her in the jail. It was probably Crystal's low point in her life. And what she said about Heather was, she reminded me that I still had value and purpose. When I felt I was falling apart, she was there for me. But what I hope you see from the sentencing memorandum is that what Heather has done with her time waiting for this day is to try to build people up. I ask you to adopt the joint recommendation.
I want to start by saying that I want to take accountability for the wrong choices I've made that have brought me here before you today. To the victims, I truly and deeply apologize to you and your family. Also to the community and to my family. I know my actions have affected them as well. Before being incarcerated, I was headed down a destructive path. I knew I needed a change. I sat and prayed, asked for a way to help me change this path I was going down. I never expected it to be going to jail, nor did I want it to be that kind of circumstance, but it was. I needed a wake-up call, and I definitely got one. This last year has been one of the hardest and most life-changing lessons I've had to go through. While being in here, I lost everything. My home, my family was divided. I was abandoned by someone I love. My oldest daughter had to take responsibility of taking care of my youngest daughter while taking care of her own child. I stood in front of the mirror and I realized I had to face myself. I had to change myself because this is not who I was or who I ever wanted to become. Remembering what my family taught me is that the greatest strength you can find to lead you on the right path is that anything is possible through Jesus Christ who strengthens you. This last year has truly changed who I am and who I want to be. It's also opened my heart to what God has called me to do. While being in here, I've attended Bible studies and groups that I'm very thankful for. They helped in growing my faith and my mental and emotional strength. When I said that God opened my heart to what He's called me to do, I say this because also while I've been
This courtroom proceeding in the state of Wisconsin versus Heather Honeyott revolves around a serious burglary and large-scale theft case involving the unlawful entry into a property and the stealing of highly valuable and deeply sentimental family heirlooms, including firearms, jewelry, and historical items, with the defendant having already entered a guilty plea to burglary of a dwelling and theft of movable property exceeding $100,000, classified as a felony, and the hearing opening with formal acknowledgement of charges and sentencing considerations before moving into detailed victim impact testimony, where the victim, a local business professional and taxpayer, explains his strong community ties, family background, and contributions to local organizations, emphasizing his lack of any prior relationship with the defendant and stating that she never had permission to be on his property. Then, describing in detail how in March 2024 he discovered his pole barn had been accessed without forced entry, noticing immediate signs of disturbance and realizing that a hidden, buried safe containing irreplaceable family property had been stolen. A safe which he had placed in a concealed location under dirt and heavy objects, specifically to protect sensitive heirlooms after previous difficulties accessing bank safety deposit boxes following family deaths. And inside this safe were items of both financial and profound emotional value such as a 9mm handgun, a multi-generational diamond ring from his grandmother, a watch belonging to his great-grandfather, and gold and silver coins, all of which represented irreplaceable family legacy items intended to be passed down to future generations, with only a few trusted family members knowing the location of the buried safe, raising serious concern about how the perpetrators managed to locate it without visible signs of disturbance or forced entry, leading the victim to conclude that individuals with inside knowledge or connections, including a former contractor who had access and was associated with people connected to the defendant, likely played a role in expressing strong belief that multiple people must have been involved due to the physical difficulty of removing such a heavy object without assistance, while also explaining the emotional impact of the crime, stating that the theft caused extreme anxiety, fear, and a loss of sense of safety in his own home, especially considering that the stolen firearm increased security concerns for his family, including his wife, elderly mother, and young children, aged 5 and 2, prompting them to install additional security measures while continuing to live in fear. And further noting that after the initial burglary, another break-in occurred targeting a separate shed on the property while neighboring properties remained unaffected, reinforcing suspicion of targeted criminal activity, and expressing that, while the financial value of the theft is significant, the greatest loss is the sentimental heirlooms, particularly the diamond ring intended to be passed down to his son's future wife, highlighting the emotional devastation over monetary value, and urging for accountability while offering conditional forgiveness if other perpetrators are identified, though stressing that lack of cooperation and failure to recover stolen items make the offense more serious. The prosecution then presents its case, emphasizing the strength of evidence linking Heather Honeyott to the crime, including physical evidence, such as a cigarette butt found at the crime scene despite her claim she had never been there, digital evidence including the presence of her phone in the same area, and suspicious communication records between her and individuals connected to the only outsider who knew the safe's location, suggesting coordination and planning, as well as recovered stolen property traced through a network of contacts, identified via phone logs and associations described as a 7 degrees of separation connection chain, showing how stolen items moved through multiple individuals potentially linked to the defendant, thereby reinforcing the prosecution's argument of involvement in an organized theft operation. The state further argues that law enforcement has strong suspicions regarding additional co-conspirators with more extensive criminal histories who are believed to be the primary planners and executors of the heist, including individuals associated with the contractor who originally had knowledge of the buried safe, and explains that the relative strength of evidence against the defendant compared to others may be due to the more sophisticated criminal behavior of those individuals. such as avoiding communication traces, not carrying phones during criminal activity, and minimizing physical evidence, making prosecution of them more difficult, and thus justifying the plea agreement as a practical resolution in a broader investigation. The prosecutor also characterizes the crime as a highly significant burglary, involving possibly one of the largest value thefts in the county's history, emphasizing that probation would undervalue the seriousness of the offense, especially given the coordinated nature of the theft and the ongoing investigation into multiple involved parties. The defense attorney responds by acknowledging the seriousness of the offense and the ancient moral principle against theft, while emphasizing proportionality in sentencing, arguing that the severity of the charge is driven primarily by the monetary value of the stolen property rather than violence or physical harm, noting that no one was injured, threatened, or directly endangered during the offense, and urging the court to consider that the defendant is not inherently dangerous and that the legal classification stems from property value rather than violent conduct, while also presenting the defendant's background and arguing for leniency based on personal growth during incarceration, including participation